Hi folks, this is the fourth time I've tried to do a screencast to go over the Obergefell quiz. Um, so if you're hearing this, I was successful, and if you're not hearing it, I was not. Um, if we took this quiz in class, we'd go over it afterwards, and so that's what I'm doing now. So if you have any questions on your answers or on it, things like that, this is a good place to find the answers to those. Let's go. Here we go. Question 1. What is or are the constitutional provisions that issue in Obergefell? It's the 14th Amendment, which has both a due process and an equal protection clause. And so the issue is, do the due process and equal protection clauses in the 14th Amendment provide a constitutional right to same-sex marriage? And if so, are state laws that prohibit that right or limit that right unconstitutional? What Federal Circuit Court of Appeals issued the decision? That was the Sixth Circuit, which covers Ohio and some other states in the Midwest. A fairly conservative circuit, which is part of the reason why at the Circuit Court of Appeals level, the majority found against Obergefell and in favor of the state of Ohio. It was a three-judge panel at the appellate level. Two of the judges wrote the majority opinion and basically said that, look, seismic monumental changes in kind of American domestic structure should not happen in a courtroom. They should happen through the ballot box and through the will of the people, through legislation, and that if society was moving towards recognition of same-sex marriage, it should happen at the state level and through the ballot box, and not be issued as a dictate from a court. The dissent at the appellate level was pretty vociferous and said, look, that's not how constitutional rights work. If courts look at the Constitution and determine if a right exists there, and if that right exists, it applies to all Americans. And so our job is not to kind of wait for the people to recognize a right. It is to determine ourselves if the right exists. And in the dissent said, no, the right is here. And the Supreme Court agreed. They said, yes, this right exists in the 14th Amendment. They voted 5-4 in favor of the petitioner, Obergefell. Justice Kennedy, who was the swing vote at that point, wrote the majority opinion. What does it say about the fundamental rights and the will of the majority? It basically says what I just said, that fundamental constitutional rights are not subject to the will of the majority. Now, the majority can amend the Constitution. There's a mechanism for that. It's a pretty complicated mechanism. It requires a very high level of agreement to amend the Constitution. But we know it can happen because it has happened multiple times, right? We know all about those amendments. Each of those amendments had to achieve a certain threshold to happen. So it's possible to amend the Constitution, but until that happens, the court's job is to interpret what is in there and what it means. So that's what they did. And they said, look, if it's in there, it's not subject to a majority vote. Question 6. Obergefell makes it illegal both for states to ban same-sex marriage and for states to refuse to credit other same-sex marriage licenses. Remember that Obergefell and his partner went to Maryland and got married legally, came back to Ohio where they lived, and tried to get their marriage license credited because one of them was dying, and the surviving spouse wanted to make sure, they both wanted to make sure that the surviving spouse was afforded all the benefits that a spouse is entitled to when the other spouse dies. So that particular fact pattern was about the refusal to credit a same-sex marriage license granted in another state. But the Supreme Court went further and said, that this is a constitutional right. Not only do states have to credit other licenses, but they cannot ban same-sex marriage within their own states. 7 words or less. What proposition does Loving stand for? Loving stood for the proposition that the right to that there was a constitutional right to interracial marriage, or that there was that state laws that purported to make interracial marriage illegal violated those people's constitutional rights and were unconstitutional, and again fell short of the 14th Amendment. And Loving was an enormous watershed case at the time, and it went a great length towards. I should say that Loving Loving was a huge step towards against racial discrimination and towards racial equality and towards other individual rights. And Loving was also a one step in the progression of cases that resulted in additional individual rights under the 14th Amendment being recognized, including Obergefell. You wouldn't have had Obergefell if you hadn't had Loving first. There are several cases that build on one another. And each of those cases may be both a watershed case in their own right, and then also a case that builds so that other cases come after it. And that's what Loving was. Question 8, extending a middle finger to a public official with no other conduct considered protected free speech. What repercussions might you face? Well, I want to be clear that I'm not advocating you do this. I don't think it's a good idea or really appropriate. There are ways to protest that are more effective and less uncouth, but generally speaking, extending your middle finger to a public official with no other conduct is considered protected free speech. And as a result, you can still get in trouble for disrupting an official proceeding or for other things or for harassment or perhaps threatening, things like that. But that the gesture alone without more is normally considered protected free speech. Now, you might still face private repercussions for it. If you're on the front page of the Boston Globe or the front page of the Springfield Republican or on the news for doing this, you might lose your job. You might be shunned in your neighborhood. All kinds of things might happen to you. But and this comes from a famous case where a police officer pulled over a motorist for speeding, decided to give the motorist a warning. And as the motorist drove off after getting the warning, the motorist gave the police officer the middle finger. The police officer pulled the motorist back over and said, "Hey, you know what? Just for that, I'm going to give you a ticket now for speeding, not a warning." And the motorist sued, and in fact, the court determined that because the initial traffic stop had ended with the issuance of the warning, the issuance of the ticket was only based on protected free speech and was therefore invalid. Still kind of a jerk move, but in that case, the ticket was void because the motorist was given the ticket for protected free speech. Question 9: what happened with Ukraine last time and what's happening now? Well, Ukraine has long been a hotbed of intrigue and international turmoil. It was a vassal state for Russia and a member of the Soviet Union for a long time. It achieved independence, after the end of the Cold War, and for a long time after the end of the Cold War, Ukraine had presidents who were very strongly pro-Russia and also pro-Putin, maybe more pro-Putin than pro-Russia actually. And when reformers would make headway in Ukraine, bad things could happen to them. There was a reformer named Yushchenko, Yushchenko, who was a reformer presidential candidate who was poisoned and nearly died during the campaign for president. He still won, but then he was defeated years later. And now we've got Zelensky, who is also a reformer, who is doing an incredible job uniting the country and providing far more resistance than I think President Putin expected. In the last administration, there was a phone call in which President Trump appeared to condition the provision of congressionally approved weapons to Ukraine on President Zelensky announcing an investigation of then candidate Joe Biden and his son Hunter Biden, who had some business dealings in Ukraine. And people who heard that call reported it because it appeared that it was the conditioning of the performance of an official act on a matter of personal political gain, which would constitute corruption and was the grounds for, in the Constitution they say high crimes and misdemeanors can provide the basis for impeachment. And President Trump was impeached in the House of Representatives, then acquitted in the Senate and stayed president. And there's lots of discussion now about would President Putin have invaded Ukraine in the same way if President Trump was still president. Well, that requires a level of kind of geopolitical strategizing that I don't have the answer to, but I will say that the question I think you'd have to ask is, would President Zelensky have felt as confident making the dramatic appeals he has made to the West and putting up the resistance he had put if he did not feel as if the West, particularly the United States, would provide a strong resistance to Russian aggression? And if the United States was still in a posture where it was talking about withdrawing from NATO or withdrawing from other international agreements, then perhaps NATO might not have been as resolute in its opposition, and it's unclear what would have happened. But what's happening now is that NATO is resolute in opposition. It's kind of has a reason to exist now, and the invasion is going far less well than President Putin, I think, expected. Question 10, what sort of diversity is most important to you on the Supreme Court? Racial, ethnic, gender, professional background. There were no wrong answers here, obviously. I think what I think is that the more diversity you have, the more diversity of thinking and of perspective, the more you have these very, very smart people looking at issues from different ways and thinking about them in different ways. And so for me, all this diversity is good, especially when you think about things like, obviously racial, ethnic, gender diversity, sexual orientation diversity provide perspectives that are needed and important. But also things like educational background. If you have all these justices coming from the same schools of thought, from the same law schools, Yale and Harvard, then you might be concerned about, do they all think the same way? Have they all been educated to approach issues the same way? Now, the flip side of that is that, of course, you want these Supreme Court justices, the most important lawyers in the country, the most important judges in the country. You want them to have achieved a level of professional excellence or demonstrated it. And of course, if you measure that by a Harvard law degree or a Yale law degree, that's one way to measure it. But you can also measure that by other things. And of course, Harvard and Yale law degrees aren't necessarily available to everybody, even if they're deserving. And for a long time, if you think about this, for a long time, minorities, women were not allowed to go to law school. So for all those years, these degrees were not available at all to people who might otherwise have been qualified. Another thing that I think is good is diversity of background. Right now, the President Biden's first Supreme Court appointee, Ketanji Brown Jackson, has among her professional qualifications experience as a public defender, which is a new thing for a Supreme Court justice. And it's actually going to be something that she's going to have to deal with in her confirmation hearings because people are going to make an issue out of it. But that's a new perspective that's being offered to the court, in addition to her kind of racial and gender diversity that she'll bring to the court. So in my opinion, diversity that encourages the justices to have a broader perspective on the issues that they face and challenges their thinking is a good thing. And I think a lot of folks took note of that as well. All right. Thank you very much, and talk to you soon. Bye.